We're going to be looking at these rules today in the context of fact patterns, complex fact patterns. And every one of these fact patterns was taken from an actual case, so we have an objective outcome in the case, either from the appellate division of the Supreme Court or, some court of appellate authority. So we'll be able to kind of at the end of the day show how all this discussion came out. You're going to see that a lot of the rules bleed over into each other, and there may be multiple legal issues, evidentiary issues coming up in any given pattern, okay? There are 5 different fact patterns we're going to be, switching around. We all have kind of individual responsibility for them. So let's go to number 1. Now, number 1 involves a little play. The actors will be Joe and me. Everybody ready? This is a real transcript. Here we go, Joey. Now, here's the setup. We're standing in the Superior Court of New Jersey, Bergen County, all right? And Joe is a Superior Court judge. So they're under a serial witness complaint, all right? Go.
Okay. Now, the state is asking you to testify as a witness in this case, the alleged victim. And I assume that they wanted you to testify consistent with the statement that you may have given and that I don't have a copy of. I don't know what it says. I wouldn't understand it if I had it. Do you intend to testify and answer the state's questions?
Yeah, I intend to. I talked to, I guess, it's the prosecutor, and I made it clear to him that I can't recollect everything that happened that night due to the fact that it was late at night, and it was a long time ago, and I was drinking. But I'm going to testify to the best of my knowledge.
Yeah, well, do you realize that if I deem you to be a reluctant witness, that I can then have the prosecutor question you about the specific statement that you gave to the police?
I don't understand that part.
Well, you gave a written statement to the police, correct?
And here's the prosecutor. That is accurate. Or is that accurate, Mr. Prosecutor? And here's the prosecutor. Yes, that is correct. She gave a handwritten statement, and she gave a formal written statement.
Now, have you had the opportunity to review that statement?
Yes, I have.
Okay. And have you reviewed both of them? Yes.
Yeah.
And do they help refresh your recollection as to what you told the police?
A little bit.
Now, if you were asked to testify and you were asked questions about your recollection, they're going to show you that, they're going to show you that statement, and they are going to show you a handwritten statement in the other one. And they're going to expect that you are going to testify consistent with that. Was that the truth when you testified to it? Strike that. When you gave those statements?
I can't remember that night, Your Honor. What I said, and if it was.
Even being shown the document doesn't help refresh your recollection?
No. If it's possible, I could write a statement out now, and I could testify to that.
How could you write a statement out now? You just said you don't remember anything.
Because I told you that night I was drinking, and it was late at night, and I was frustrated. There was just a lot going on that night. All right, everybody got the setup? This is a real case. Judge McGady, what do you think?
All right, Bob's asked me to talk to you about dealing with the admission of prior inconsistent statements, which this would probably lead to. The first case, a Supreme Court case that came out in 1990, State versus Anthony Gross. Coincidentally, the second case we're going to talk about is State versus Frank Gross. Came out the exact same day from the Supreme Court, just totally trying to confuse us. Let's go back to Anthony Gross. It's kind of the genesis of this proceeding. Facts in that case were that the defendant had forced his way into a man named Pinkney's apartment, and Pinkney got up and kind of objected to the fact that they were forcing their way in, and they shot and killed him. But at least it was worthwhile. They got $4 out of the robbery. At the trial, a fellow named Clifford Plant, who was serving time on a plea to complicity to this same forced entry, testified in the Pinkney murder trial. 2 weeks after the murder, Plant had gone to the police and he had signed a sworn statement that the defendant and 2 others had gone into Pinkney's apartment. Plant claimed that he had remained outside in the hallway, but he heard a shot. That was the shot that killed Pinkney. And while he couldn't actually testify who shot Pinkney, he could testify that the defendant, Anthony Gross, entered the apartment with a rifle in his hand and came out of the apartment with a rifle in his hand, but that's the best he could do. Plant agreed to testify truthfully in accordance with the statement that he had given to the police. At the trial, Plant surprisingly reneged, and he claimed that he only agreed to testify in the other person's trials, not into Anthony Gross's trial. The statement that Plant gave was in the presence of his father. Apparently his father accompanied him to the police headquarters. He had been given his Miranda rights, and he signed and swore to the truthfulness of the statement that he gave. At the trial, he testified that he didn't know the defendant at all, and he first saw the defendant when they were both imprisoned after the murder had taken place. The prosecution now sought to enter that statement that Plant had made as a prior inconsistent statement. Plant disputed the validity of the statement, said he was handcuffed to a chair when he gave the statement, and that was for a 4-hour period, that the detectives actually put a plastic bag over his head, and that when he did sign it, he actually only read a small portion of the statement before he signed it. Contrary to his statements, a sergeant took the stand and testified that none of that was true and that Plant actually made corrections to the statement and initialed the corrections. The issue then became the standard that would govern the admission of the prior inconsistent statement, inculpating a criminal defendant by a witness who was in police custody at the time as a criminal suspect himself. It went all the way to the Supreme Court. That's a little confusing because the Supreme Court in 1990 was dealing with the old rules, Rule 63, which is now Rule 803 of the evidence rules. And it said that it concluded that prior to even the existence of Rule 63, a prior inconsistent statement could only be used for impeachment purposes and not for substantive evidence in New Jersey courts. But that since then, New Jersey has moved away from that, and it does allow it to be used as substantive evidence in certain conditions, provided, namely, that the witness be available for cross-examination. In other words, the recanting witness has to be available for cross-examination at some point. Rule 63 had specific requirements that were to be analyzed in terms of establishing reliability. That's the key term, reliability of the prior inconsistent statement. And some of the requirements were that it has to be in writing and signed or under oath, subject to perjury in some kind of pre-trial, trial, or deposition hearing. The court determined that the standard for determining the reliability of the prior inconsistent statement for substantive purposes should not vary according to the status of the declarant. In other words, whether he was a witness, whether he was an accomplice, a suspect, whatever, there shouldn't be any differentiation in the how it's examined. It's still, the underlying key is whether or not it's reliable. Rule 63 requires that the statement be made by a person who's now a witness. So clearly, we're not even into this prior inconsistent statement unless the person is in the courtroom, the witness is here. And now that he's in the courtroom, he's subject to cross-examination on that prior inconsistent statement.